I am still talking about the corruption of Judge G. Thomas Cooper, Richland County Court of Common Pleas. I filed this order in two most recent videos just to show you how corrupt he really is. So I'm going to move quickly through this, but I'm going to focus my attention on page 3 and page 4. When Judge G. Thomas Cooper Jr. dismissed this case on October 8, 2015, he was unlawful and not justified in doing so. On page 3 at number 2, the South Carolina Supreme Court has defined abuse of process as employment of legal process for some purpose other than which it was intended by law to effect. The improper use of a regular scheduled process. When South Carolina Department of Employment and Workforce applied bar from applying does not meet minimum qualification and candidate has been marked. That was for other purpose for what it was intended, because bar from applying denied me job opportunity, so I met the standard. It is distinguished from malicious prosecution by saying it involved the malicious misuse or perversion of the process. When Agent Sorensen of South Carolina Department of Employment and Workforce HR Office applied bar from applying on July 19, 2013, not to expire until December 30, 2018, to deny me job opportunity. That was malicious misuse or perversion of the process. And so it was used to cause harm. I met the standard. He goes on to say, the element is articulated. 1, an ulterior purpose. South Carolina Department of Employment Workforce objective is to assist job seekers with job opportunity, not to deny them. And so when barred from applying, and others were applied on July 19, 2013 to December 30, 2018, denied me job opportunity. I met the standard. Number 2, a willful act in the use of the process, not proper in the regular conduct of the proceeding. When Agent Sorensen of South Carolina Department of Employment and Workforce applied bar from applying for 5.5 years to deny me job opportunity, that was not proper in the regular conduct of the proceeding, because South Carolina Department of Employment and Workforce objective is to help job seekers attain job opportunity. I met the standard. The second element, a willful act, has been described as some definite act or threat not authorized by the process or aimed at an object and legitimate in the use of the process. When Agent Sorensen, a state employee who worked for South Carolina Department of Employment and Workforce, a state agency, used a state agency computer to apply bar from applying on July 19, 2013, not to expire until December 30, 2018, denying me job opportunities. She knew that employers, when receive my application, would see that legal bar will automatically deny me job opportunity. I met the standard. He goes on to say the willful act element consists of 3 components. 1, a willful or an overt act. The secret blackballing effect and the application of bar from applying and others to deny me job opportunity without notification and without justification. I met the standard. Number 2, in the use of the process, when Agent Sorensen of South Carolina Department of Employment and Workforce applied bar from applying on July 19, 2013, not to expire until December 30, 2018, denied me job opportunity, which is not the objective of South Carolina Department of Employment and Workforce. I met the standard. Number 3, that is improper because it is either unauthorized or aimed at an illegitimate collateral objective. When Agent Sorensen applied bar from applying and others to deny me job opportunity for 5.5 years, She knew that it would deny me job opportunity. She knew that it would be a character assassination, not based on who I was as a person, not based on my education experience, and not based on my direct professional work experience at South Carolina Department of Employment Workforce through Lower Savannah Council of Government in Aiken, South Carolina. To the United States Department of Justice, I am requesting an investigation into the misconduct of office by Judge G. Thomas Cooper Jr., Richland County Court of Common Pleas, to deny civil rights claims against the state of South Carolina. He was unlawful and unjust to do so. He is corrupt to the core. And to the state of South Carolina, you refuse to say my name. I said my own name, and justice is still required.